thing is I hope that I can impart something to you that will enable you to win. Because I love to win, I hate to lose. I'm not interested in riding a rocket into outer space if I'm going to burn up on reentry. I want to win. I want to win. Now, we're going to discuss 4 actual cases of real, live people. Let's go back and review. Courts of inferior jurisdiction, where we have to start out. How do they get jurisdiction? That's right, from pleadings sufficient to invoke their power to act. And where do they get these pleadings? They get them from the people that are litigating when they do it right. We have a common sense, which means that before we know what any statute, rule, constitution means, we're going to have to look at what the Supreme Courts have ruled and determined that it means, and we find that where? In the state annotated. Jurisdiction is a 4-legged table. You've got to have 2 people. You've got to have the subject matter, and you've got to have the competent witness. If any of those elements is missing, the table falls down, it's void, and is subject to being vacated. Now we're going to start looking at some actual cases. The first case that I'm going to tell you about is Tim. Now, before I tell you about Tim, there is a pass-out in your materials that I hope is handy. And this is a letter to a collection agency. Anybody ever heard from a collection agency? Okay. There is a letter to a collection agency that I have used by count 9 times. There has yet to be reported to me a single response. This letter will empower you to learn. Do what? Yeah, I think it is. Yeah, it's this page. It's this page. This empowers you to learn whether the people that are calling you on the phone and writing threatening letters have the authority to do that. If you send them this letter, you will find out fast whether they do or not. Because you'll probably never hear from them again. I've used it 9 times. Nobody's reported to me that they've ever heard from them again. Which tells me that those collectors were trying to run a con game. If they had legitimate rights, they would have pursued them, but they didn't have legitimate rights. And once they were confronted with something that was sufficient, then they decided that they better go pick on somebody else. Now this brings us to Tim, a real live person that I work with. And this happened 3 years ago. Just happened to run into him at a hockey game. And I don't go to very many hockey games, but anyway, ran into him at a hockey game. And Tim said, with a great deal of urgency in his voice, "You're a lawyer, aren't you?" No, I'm not a lawyer. "Well, you do legal stuff." "Well, yeah, I do legal stuff. What's your problem?" He said, "Well, I've been sued." "Well, how do you know?" "Well, they sued me. I got this summons. Said, you've been sued, and I'm going to have to go to court. They sued me." I said, "Well, maybe. Maybe you've been sued, maybe you haven't." Now, why did I say that? Well, because I suspicioned that it would be the typical BS. And again, what was I relying on? I was relying on the law, because the law says in a disputed matter does not become a case or a proceeding until the law provides for a hearing before a court, and therefore any matter is first judicially determined in a court of some nature. In other words, until you've put the 4 legs under that table, it's not even a case yet. It's not even a case. Now again, I'm not saying this because I love it. I do. But I'm saying it's because of the law. This can go with those others for copying back there. So Tim thinks that he's been sued, and probably 99% of all lawyers and even a lot of judges probably thought he was sued too. And I said, okay, here's what you do. He said, bring me the paperwork. He brought me the paperwork, and I looked at it, and I said, you haven't been sued yet. And he said, but it's a summons. And it says you have been sued. You have 20 days to answer. And I said, yes, but you haven't been sued yet. And here's the reason why. Now, Tim's too young to remember very much about Judge Waltner. But Judge Waltner always began by saying, I've read your complaint. I know you've been sworn. There was nobody in here swearing. Who was injured? Somebody says, I'm injured, then you've been sued. But until that competent witness appeared, it's not a case yet. That's what the law says. And I said, here's what you want to do. Go down to that courthouse. You ask for this case file number. You look in there and you tell me if you see an affidavit. Because if you don't see an affidavit in there, they have yet to name a witness. If there's no witness, there's no injury. If there's no injury, there's no wrong. If there's no wrong, there's no remedy. There's no case. All right. So he went to the courthouse, and lo and behold, when he looked in his file, there was no affidavit. And so he calls me and he says, well, now what do we do? So I say, okay, here's exactly what to do. You compose a letter and it goes like this. It is not now, nor has it ever been my intention to avoid paying any obligation that I lawfully owe. In order that I can make arrangement to pay the obligation which I may owe, please document and verify the obligation. So you make 2 copies. You carry it over to this lawyer's office. You ask him to sign for one of them, and then you ask for the documentation and the verification. Now we know from this morning who can document and verify that. Can that attorney? No, he can't do it. And I'd already coached him of what to say because I was already anticipating what would probably be said. And that attorney said, well, you're here to start your installment payments. We'll get you started. Tim said, no, I'm here for the documentation and the verification of what I owe. Oh, well, yeah, we can document that and we can verify that and we can get you started on some payments. It'll be easy for you to afford them. So, no. I want you to document and verify what I owe. The attorney said, well, now, if you're not going to cooperate, we're just going to have to go ahead and sue you. He said, no, you're not cooperating because I've asked you to document and verify what I owe and you're not doing it. Now then. Is that better? So what we did is we answered their suit, but we also countersued them for fraud and bad faith because they had advanced documents expecting another person to rely on them, which they would surrender money, property, or rights that they had to know were false. How did they have to know that they were false? Because that attorney had an obligation under oath to make an inquiry reasonable under the circumstances to determine whether or not there was an actual obligation. And when he couldn't document, I mean, how hard could that be to document? And when he couldn't document it, that told us that he had committed fraud. But he had committed fraud in the name of the finance company that was now suing him for a deficiency. Now, this Tea Party went on for well over a year. And twice they tried to get a summary judgment against Tim. The lawyers wanted their money, and it wound up there was a team of 3 against Tim, and that's usually how it works out. These guys are so confident in themselves, pleading against a pro se, that they have to show up with a posse. But let's look at the second response to the motion for summary judgment. That's part of your materials. And that's identified as defendant and counterclaimant, John Doe citizens, response to plaintiff and defendant on counterclaims motion for summary judgment. Okay, what's our premise we're going to proceed under? Plaintiff and defendant on counterclaimants motion for summary judgment is a substantive and procedural nullity. Pretty heavyweight words for somebody representing themselves going into court. Brief and support. Plaintiff and counterclaimant has placed no facts on record. No fact appears on record, whether by deposition, admission, answer to interrogatory, or by affidavit to suggest or to support the averments of plaintiff and defendant on counterclaimant's pleadings. Documents proffered by Dewey Cheatham, it's not the attorney's real name, are unverified, out of date, irrelevant, and inadmissible. The record shows that the defendant and counterclaimant, John Doe citizen, has testified and testifies again infra, establishing that material facts to which there is substantial controversy are at issue in this case. What's accomplished in this first paragraph? First of all, when you're in a pleading form, you want to know what it takes to win with that form. And when you want to win against a motion for summary judgment, you've got to state that there is a controversy. If there's a controversy, there can't be a summary judgment. And you're stating that there is a controversy. And so the court cannot decide this against you. And you're also saying that the only person that said anything in this tea party is an attorney. And I don't care how high the stack of paperwork gets from an attorney, it never, never rises to a level of fact. If you look at the clear letter of the law as determined by the Supreme Courts, the judge is not even supposed to look at it. It's not supposed to be noticed by the court. Just like Sanders Sauls down there in Florida with those stacks of 20,000 ballots in there, it wasn't noticed by the court because it didn't come through a competent witness. Now we go ahead and state what we feel the controversy is. And then we come down to the argument and authorities, which is the holdings upon which we are basing our empowerment of the court. This is how we empower the court to make a ruling favorable to us. Argument and authorities. Statements of counsel in their briefs or argument are not sufficient for purposes of granting a motion to dismiss or for summary judgment. Trenzi versus Pagliaro. Unsupported contentions of material fact are not sufficient on motion for summary judgment, but rather material facts must be supported by affidavits and other testimony and documents that would be admissible in evidence at trial. And it gives the authority for that. Where there are no depositions, admissions, answers to interrogatories, or affidavits, plaintiff's motion for summary judgment could not be considered under District Court Rule, Oklahoma Statute 12, Chapter 12, Rule 13, providing for judgment where facts are not controverted, inasmuch as there was a complete absence of any requisite basis, misspelled basis there, for proper determination that no substantial controversy existed. And it's coming from where? Our annotated statutes. Any ruling on a motion for summary adjudication must be made on record parties have actually made and not upon one that is theoretically possible. And then I go ahead to list some other authorities there. But it goes right directly, exactly to what we've been talking about. The other side was not entitled to a judgment. They hadn't even established a case yet. Do you think that this is unusual? No. I estimate that this has happened 50 million times in this country because our legal system is so rotten. Attorneys are so lazy, incompetent, and utterly stupid. So, actually happened in the case. Well, what happened is they fought on for about another month or so after this, and they called him and they said, "We will leave you alone if you'll leave us alone. Will you please leave us alone? Will you please drop your suit? We'll drop our suit if you'll drop yours." Well, I left it for Tim to decide what to do, because I wouldn't have dropped it, because I want to win. But he had had enough after nearly 2 years of having these people as if they had a gun at his head, that he was really ready to drop it and let it go. But I hope you agree that in the time from when he frantically said, "I've been sued," and when the amount that they were claiming that he was going to have to pay was about $6,000, to actually being able to walk away was not just a victory. It was a tremendous victory in the context of a system. If the pleadings are right, you can win. That's the Tim story. Do you like the Tim story? Now we're going to talk about the Dorothy story. Anybody here ever had a credit card that they kind of had some problems with? Well, I tell you, this credit card business is a racket, isn't it? It's horrible. It's horrible. Well, Dorothy, who is now 70 years of age, had a credit card like most of the rest of us do. And you know, those things are just addictive. And that credit card just got to have a bigger and bigger and bigger outstanding balance. And it eventually got to the point that it was just, she was never going to be able to pay it off. All she could do was just manage to make the monthly payment on that thing, which with its excessive interest rate means that you may never pay that thing off. Dorothy paid conscientiously and probably would have on and on and on, except she had another little problem called the IRS. The IRS worked her over, and by the time the IRS got through working her over, she was ready to quit work. And when she quit work, she did not have the financial means to pay that credit card. The credit card went into default. And then what happens when a credit card goes into default, usually? What do they usually do? They sell it. They sell that obligation. Unless that promissory note is transferable. And even then, only with proper notice. If you sell it, it's dead. It doesn't exist anymore. It's gone. Killed it. Well, it depends on whether there's a transfer clause in it. And if there's a transfer clause, it can be sold if they give you proper notice.
We have a thing on taxes where the so-called county clerk sells it to the sheriff.
When you have problems, and they could be extreme, that is a great opportunity for you to really practice transcending that situation and work out not allowing it to bring you down consciously. That's the mission. That's the mission, to be able to navigate all of the challenges of this world that it may bring you and still be able to walk over it like Christ walked on water. Still be able to allow yourself to be sacrificed for the good of mankind. I'm not saying go allow people to nail you to a stake or anything like that. What I'm saying is, spiritually, even though these people, you might feel from a fleshly level that they deserve condemnation, you cannot condemn. Because once you don't allow yourself to pass judgment on them for their wrongdoing, and you look at it as simply as, forgive them, Father, they know not what they do. And honestly, so people are so indoctrinated into the opposer mindset, into the devil mindset, that what they do, although it may be wrong to some and most people, they really don't see it as wrong. They really can't see it because their mind is so clouded in that vibration that in that world they feel justified. You just so happen to be a casualty of their ignorance to their true divinity. Peace. What's up? All right. Mike look like it's working. Hey, how y'all doing out there? It's Tuesday, April the 8th, 8 days into the month of April, fourth month of the year. The flowers are coming back. I've been walking on this trail all winter, and when all the leaves go away, everything looks, naked, desolate. Now the leaves are coming back, the greenery, things that I used to be able to see off in the distance in the woods, I can't see it anymore. It's really nice to see how that, how things change and when the weather gets warmer. But I hope everybody's doing good. I'm doing great. Been working real hard. I did that webinar Saturday. We had a decent turnout. That will be available. That recording will be available. It's already ready. I just have to put it on my website, so that'll be available if you want to catch the replay. Akimel.com. It'll be there. So there are probably going to be 2 or 3 versions of that same. I did a 2-day webinar back in March the 1st, and then I did a seminar in Maryland, which I wasn't able to record. Then I did another webinar Saturday, which is a combination of both those 2 webinars and seminars together with some extra information like the Jubilee letter to get rid of your debt. And those who had joined that webinar was able to get that for free it was included with their purchase. Of course, when I put it on the website, it's going to be more than what, it's always cheaper to join the webinars when they're live. When I make recordings of them and I put them on my website, it's going to be more. It's going to be more. Because why? Because you get to keep it, watch it over and over and over and over again, and absorb the information. You have to watch things more than once to really get it. And then I charge more because there's people who come in and make a business out of my videos. I have confirmed 2 people have started up their own networks using my information. But here's the thing. Why I don't get too upset about it, but I do call it out. One of those things that you really can't do a whole lot about. If I spend my time chasing after that, I won't have time to get into the zone to create new information. And when you have a creator who's creating things for remedy, those things come from a higher place. So it can never be taught from the position that I stand. No one else could teach it like I teach it. No one know what inspiration came from what I'm talking about or what I'm teaching. This is like an artist who paints something, right? And you try to copy his work. You're not going to get the feeling, the spiritual connection to the painting that the actual artist has. Like what I do is an art to me. It's art. Just happens to be in the space of law. So like that Jubilee debt letter that I just introduced, that's going to be, people going to start calling that, right? Just wait about a month. You see, I got to do Jubilee this and Jubilee that. Watch, you'll hear it. You going ahead. But that came from a space of inspiration. I was sitting there laying down in the hotel room and boom, the word of God came through me and I put it together. Of course, that letter that I introduced is in its raw form. It was the first draft of the inspiration. If you guys know me, I always have a 1, 2, and 3, 4, 5 versions of information. Why? You have to upgrade in this system. If the Matrix didn't teach y'all that, they're upgrading, you got to upgrade. You see? So, yeah, they a couple of people made, I think it's actually 3, somebody out of New York. And all of those people that was dealing with that person is coming to me because they are having issues. That's typically what happens. So I was playing Richard Cornforth today, and there's a reason why. Because I really gotta bring this home to you guys. You guys gotta realize a lot of these debt collectors suing you, they really don't have standing to even sue you. Like they'll come with empty complaints. Let me see if I can find one. An empty complaint. That I'm gonna read a complaint to y'all. A very empty one at that. Let's see if I can find I was just reading it. Now I lost it. Let's see. Maybe it's here. It was a one-page complaint, and it basically was saying, here it is, I found it. I'm gonna read this to you. It says the complainant, the plaintiff, I'm gonna leave out names and all of that. The plaintiff complaining of defendants alleges and says plaintiff is a national bank located in Utah. The plaintiff is informed and believes that the defendant is a resident of, and then they go on to the resident stuff. Then it says breach of contract as the subtitle. Defendant entered into a credit agreement with the plaintiff. The credit account is identified as account number ending in blank, blank, blank. The defendant agreed to pay and was obligated to pay the plaintiff for the extension of credit obtained together with contractual interest fees pursuant to the credit agreement. The defendants used or authorized the use of credit card or credit account to obtain extensions of credit by such action assume the obligations of the credit agreement. Plaintiff duly issued to defendants periodic statements of account that set forth the transactions on the aforementioned account owing by defendant. Defendant have breached the repayment terms of said agreement and indebted to the plaintiff in the amount of undisclosed amount. We're not going to say the amount. Pursuant to the terms of the credit agreement, plaintiff elected to accelerate the entire balance due and owing upon the breach of contract by the defendant. Plaintiff has made demand upon defendant for payment of the outstanding balance, but defendant have failed to pay the outstanding balance. Wherefore, plaintiff demands judgment in the amount of blank blank against defendant plus post judgment interest and court costs to the extent permitted by applicable law. That's the complaint. No exhibits, nothing. What's wrong with this? What is wrong with this? How could somebody come into court making a complaint, don't show proof of their complaint? What they're, usually when they have complaints, they'll have statements and a bogus affidavit. This is just a one-page empty complaint. It's just making all types of allegations that basically it's the attorneys trying to testify or allege to some debt that they don't even have the full teeth of what this is. And what have I always said to you guys when it comes to these things? The only person standing on at the other side is going to be an attorney, and with no one with firsthand knowledge of any facts. So, how are you supposed to respond to this? How are you supposed to respond? How do you respond? So let's see. I'll give y'all a response. I better. This is gonna be a short show because I got a meeting at 8 o'clock. Um, here's a get your pens out, or maybe you could just go back and listen to the show because this is a way you could respond. Let me check the chat. Here's a way to respond. This is just an idea of how you can respond. Get my chat up. Y'all ready? Y'all ready for me to break it down? All right, here's you just simply put an answer to it and you say answer to complaint. Now comes your name. Now, I would also I'm going to tell you this without like giving you the details of it. I would definitely make a distinction between the all cap and the actual name in the paper. Make sure that they know that you're not really addressing me, the spiritual person, the God person. You got to make them know that and separate yourself from that in the paperwork. Okay? But I'm not going to tell you exactly how to do that, not on live YouTube. That's my special sauce, and I'm going to keep that for the private. All right? Y'all following me? Y'all got your pens out? Let me check. Let me make sure y'all got y'all ready to take notes. But y'all can always go back and watch the replay. So answer to complaint. Now comes John Doe, upper and lower, and files the answer to the complaint denying the claims made by plaintiff and stating as follows. First, affirmative defense. Defendant denies each and every allegation set forth in plaintiff's complaint except as specifically admitted herein. Now, y'all remember when I was part of this other team? And they used to say, I deny, I deny, I deny, I deny, I deny. Don't do that. Please don't do that. Here's why I don't do that. I did that. That was, I took that advice and did that, and I got a response from it. Well, if you generally deny, we need specifics. You can't just say I deny without backup of why you're denying. See, I quickly realized that a lot of the court experience wasn't real court experience. Because when you have real court experience, you start to learn these things. That ain't gonna cut it. Just saying I deny all the way down and that's it. Y'all can go back to the old blog talk videos and listen to that stuff. Don't do that. If some of y'all got some residual knowledge from the past, please do not do it. Right here is I'm showing you how to defend yourself in a debt collecting suit. Right now. And remember, this is not legal advice. This is because I'm not a lawyer. I'm a minister of the word of God. So all of this is just some spiritual advice. There you go. All right. Defendant denies each and every allegation set forth in plaintiff's claim, except specifically admitted herein. I denied everything in one sentence without going all the way down. You got to rebut each one. I deny. No, you don't have to. All you have to say, defendant denies each and every allegation set forth in plaintiff's complaint, except as specifically admitted herein. One sentence. I'll give you time to write that down. I'm giving you good. There you go. Second affirmative defense. Pursuant to Rule 56E of the, I'm not going to say the specific state, affidavits or evidence presented in support of claims must be made on personal knowledge and must show affirmatively that the affiant is competent to testify to the matters stated herein. Plaintiff has not provided evidence or testimony from witnesses with firsthand knowledge of the alleged debt, rendering its claims inadmissible and insufficient to meet the required burden of proof. Because remember, if they're bringing you into court, they have to, the preponderance of evidence is on them. The burden of proof is on them, not you. That's why when they start trying to send you all of these questions to answer to trap you, no, you're not, the burden of proof on you is not on you to prove their case. And you don't have to answer those things. They could ask you, but you don't have to answer. You simply say without knowledge. And the only way they have to go to the court and force you to try to get you the answer. And even then they can't do that. You gotta say, I'm not here to prove their case. They're the one who brought this. I don't even know these guys. See, that's the other thing. You never let it get to the point where you arguing back and forth about the amount of the debt, when it was incurred, and all of that. Your only argument will be, who is this? I don't know them. These people who are bringing this claim, I have no idea. I've never sat down with them, never signed any contracts with them. So these people are strangers to me. Your Honor, these people are strangers. I have no idea who they are. They're slandering at this point, I feel like my name is being slandered. But I know how some of y'all are. Y'all get in court and y'all just freeze up. I know. I know. That's why you need to do some type of ritual before you get in there. And maybe you need to do some practicing. All right. Third affirmative offense. Under general statute, not saying the statute, documents submitted as business records must be authenticated by a custodial and other qualified witness. Authenticated. Did you hear that? So if they start entering computer records and stuff like that, it got to be authenticated by someone who's the custodial or qualified witness. And you get to question that person of oath. And guess what? Even that's not sufficient evidence, because that's just something in their computer. It doesn't say anything about what actually would happen. Like, who is to say that I am the person who did all of this? Plaintiff has failed to authenticate any documents presented or provided testimony from a qualified witness to verify the validity of its claims. Assertions made by plaintiff's attorneys do not constitute admissible evidence under the law. Fourth affirmative defense. Plaintiff's reliance on statements by its attorneys who lack firsthand knowledge of the alleged debtor transactions violates evidentiary requirements established under law. I'm saying more here. I'm being more specific, but I'm not saying it on purpose. So that's why I'm just saying law. The Court of Appeals have consistently held that assertions unsupported by competent evidence cannot form the basis for a valid claim. Then I put some case law there. Plaintiff's complaint fails to state a claim upon which this is fifth affirmative defense. Plaintiff's complaint fails to state a claim upon which relief can be granted because it lacks admissible evidence substantiating the allegations of indebtedness against the defendant. Plaintiff's failure to present evidence in compliance with the law requires dismissal of this action. Wherefore, defendant respectively requests the following relief: that plaintiff's complaint be dismissed in its entirety, that judgment be entered in the favor of defendant, that defendant be awarded any other relief the court deems just and proper. Very simple. This is what, 2 pages? 2 pages. 3 pages if you count the certificate of service. You see? But see, what I've seen people doing, they put a whole damn book in there. They talk about stuff like, I'm the man of the land, and I take your oath seriously. Common law this. They use stuff like an unrebutted affidavit stands as truth. See, I'm not in I'm not a lawyer, so I'm not going to teach them anything about law. I'm not going to tell them, well, just you this and that. And this is stuff that has been taught for years. And I'm going to tell you right now, I'm debunking all that nonsense because that's what it is. It's nonsense. It's incomprehensible nonsense. Don't get caught up with that putting all kind of unnecessary stuff in your replies to these complaints. It's very simple. The only thing I make sure I have a clear distinction between that in Legis and myself. I will do that. That will have some effect. You see? And they're not they're gonna look at that and they're not gonna even talk about that. They're not gonna bring that up because they can't admit to that. They're under oath not to admit to that. So don't expect to have a conversation about that. This is why when you go in and you use that technique, I'm such and such doing business as blah, 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 they get hostile. No, if I put something in my paperwork and I won't say doing business as, I'm not doing that. Know why that I thought it sounded good years ago, but it's where it's faulty is this. If you go in there talking about you doing business as that, then you are going to be considered a sole proprietor at that point. Basically, the trustee. And the trustee is the worst position to hold in the courtroom. I hope y'all took notes of what I just said. Because a doing business as or a certificate of assumed name holds the same weight as someone who has an LLC and they're a single member LLC, and the IRS considers them a disregarded entity. You are one and the same as that entity. Because you're saying you, the living or spiritual person, is doing business as that. And that's why that's a faulty way of doing it. Oh, I know that what I just said shoot down a lot of these teachings. And y'all could go talk to y'all guru teachers about it and tell them what I said. If you go in there as a DBA on your paperwork, you are one and the same as that ends legis if you do that. And that's how you're going to treat it. Well, hey, here's the proof. Tell me how your cases go when you do that. You see? How do they go? They get rough for you. The waters get real deep and very rough for you. Yeah, you're doing business. That's okay. There you go. We got you now. You're not doing business as that in legis. Not only that, you should never do it in a courtroom setting, especially not a criminal setting. Never. Because think about this. If I'm getting sued in a debt collector case and I go in there and say I'm doing business as that name, then I'm responsible for the debt. Huh? Y'all, is it clicking now? See, here's the problem. This is the problem. And it's been a big problem for many years. We have so-called scholars of law who think they're scholars of law, but they can't even define one word that they're reading, or they misinterpret the meanings, or they even misinterpret. What time is it? They misinterpret the readings of paragraphs, because if you understand all of the double speak, how they write stuff, the best way for me to, let me close all of my stuff out, because I ain't letting y'all see none. Not on YouTube. Be mad. It's okay. You'll live. But there's something I wanted to go over. And this you will only notice if you have read the whole law. Kind of hope I could just pull it up. This is it. I think it is. Come on, be it. Yes, this is it. There it is. There it is. Hold on. Let me just start with. All right. I want to share. Give me a second. All right. All right. Here we go. I'm going to try to do this in the next 2 minutes. I got to get on the meeting. Why is my screen share not working? Oh, maybe I ain't supposed to show y'all this. Now my screen sharing acting up. That's not the screen I want to share. That's it right there. All right. This when I was teaching on nationality many years ago. This is from the Department of State's website where you get your passport and all of those nice things, right? And in here, if you have not read the actual law that they're pertaining to, you would think all of this was just part of the same context of what they're trying to convey. But this is really a bunch of doublespeak and misdirection. So I'm going to read it. And this is how one of the ways I figured out what you needed to do with your passport, or I had already figured out what to do with the passport, but this was kind of reinforcing. And usually when I do my seminars now, I haven't read this in a while, but I'm going to go back to this to show you how a lot of people are reading things from websites, because this is just a website. This is the travel state. This is official government website, but it's not the actual law. And when they write the laws on their website, they leave a lot of stuff out. And it what it causes is misinterpretations. And this is why people was trying to get a certificate of non-citizen nationality, which is something you don't want, right? But everybody say, "Oh, I need to get that certificate." Yeah, we need to get that because they only read the title and read a couple of words here. But let's read it. The Department of State occasionally receives requests for certificates of non-citizen national status pursuant to Section 341B of the Immigration and Nationality Act, INA, and 8 U.S.C. 1452B. So that means you need to go read those, right? To understand what that's talking about. As defined in the INA, all U.S. citizens are U.S. nationals, but only a relative small number of persons acquire U.S. nationality without becoming a U.S. citizen. Section 101A 21 of the INA defines the term national as a person owning a permanent allegiance to a state. Section 101A22 of the INA provides that the term national of the United States includes the U.S. citizens, all U.S. citizens, as well as a person, though not citizen of the United States, owe permanent allegiance to the United States non-citizen nationals. So, before I get to that non-citizen national thing, most people will miss what I just read, right? I'm going to read it again to reinforce to see if you caught where they indicated what you should be and what you shouldn't be. As defined in the INA, all U.S. citizens are U.S. nationals, but only a relatively small number of persons acquire U.S. nationality without becoming U.S. citizens, period. Sections 101A21 of the INA defines the term national as a person owing permanent allegiance to a state, period. Section 101A22 of the INA provides that the term national of the United States include all U.S. citizens as well as persons who, though not citizens of the United States, owe permanent allegiance to the United States, non-citizen nationals. So I'm a interpret this last part. So a non-citizen national is simply a person who owes permanent allegiance to the United States. So that's not what you want to be. But everybody was trying to tell y'all to be that. It clearly says it. But they put all this one paragraph together, but every sentence was a different law. But what you should have been, it was right in the middle. They stuck it right in your face in the middle. It said Section 101A21 of the INA defines the term national as a person who owing permanent allegiance to a state. And it, period, nothing else. No extra words. But everybody misses that. So that means, what is the state they're talking about? Your state of foreign national status, because where were you born? I was born in New York. I'm a New Yorker, right? But to take it a little further, the other state, since they're not defining state, the other state is I am born of divinity from God. That is a status. That is a state. That's my spiritual state. But people have read this over and over again and still talk about you need this non-citizen national certificate. And if you keep and then they if you keep reading, they start talking about other stuff that confuse you even more. And really, they're not even going to produce a separate document. And then they broke it down. If you go way down, here it is. It's right there. They separate it down here. I'll keep highlighting the wrong thing, but that's it. Right there. I'm sure I just helped somebody teach this better just now. But the point of all of this I'm making is it was going back to the court situations, right? How you were being told, go in there, just blank, just say some general denial. Hang on. I'm trying to get my screen back in order. All right. There we go. Some general denial. And you really wasn't putting any teeth in it. And this is why most people lost under that method. See, me, I have failed at stuff. And to be honest, when I failed at court cases, because I was listening to somebody else and I didn't really do my due diligence and study and put it together, put all the pieces together for myself. I trusted that these people that were teaching had the experience that they claimed they had. But after further research and just looking up general cases, I couldn't I couldn't find any cases in their name. You know, the case in when any debt collector case is gonna be on a public record. I couldn't find any. I pulled up a case of mine while I was at the seminar and showed his. Like, I show y'all my stuff. Here it is. All the stuff I filed back then. All of the crazy stuff I was filing based off of, you know, bad teachings. You know what I also noticed? All the trash talking I do about those bad teachings, no one rebuts it because they can't. No one would stand toe to toe with me and well, this, that, and because they can't, because you no experience. There's no experience there in those courtrooms with cases and stuff like that. Like I said, if you really want to know how to beat your case, get that Dr. Graves How to Win in Court. It's only $200. I think it's still $250. Get it. Learn how to deal with these courts properly. They have a language. You got to learn it. You can't go in there speaking your language and they speaking a different language. You have to understand. It's like me going to a foreign country. If I really want to survive in a foreign country that speaks another language, I have to learn that language. I can't go in there with my language and expect everybody to conform to me. No, I have to learn it. This way I would be able to live a fuller life in a place like that. Being able to speak the natives' language. That's a form of respect for the people. Right? Learn how to speak court language. They're speaking Latin. Learn those Latin words, what they mean. They can fit when you start putting Latin words into your paperwork. And today, a lot of these lawyers that's coming out of school, they don't even know how to speak Latin properly. The average lawyer. You start throwing some Latin into your paperwork when you put it in. Watch how many wins you'll get doing that. All right. Let's see who's out there. Let me go down the list. I got 2 minutes. All right. Indie Circus says peace. My brother, peace back to you. Corinne says happy Tuesday. Due date is fastly approaching. Jason G. Jason in Brazil says peace. I say peace and I say prosperity and extreme wealth to all. And someone said, read, their name is Read the Constitution. I agree. Read that Constitution. That was a great video, very informative. Oh, you talking about Richard Cornforth? Yeah, it is. It's a 3-part series. If that's what y'all were talking about. Yeah. Oh, hold on. I already ordered that. Um, what was that? It said that's right. They make it a business, Yeah, they do make it a business, but they get paid off my stuff. I'm with you. Indie Circus says, they down here and they ignored all my information, had to appeal it to the appeal court where I can get my win. There you go. And then there's somebody got his sunglasses on. Sangeet Raj. Peace. What's up? Um, Not an exact world as you're saying it, but I basically said the same thing. Good. Akeem the Mythbuster. Peace, everyone. And Scale Boys, what's up? What's up? What's up? I gotta go check your food truck out. I'm gonna come out there sometime this week and get some food from you, bro. And come look you up. What's the name of the book you mentioned? You talking about Double Speak? The book is called Double Speak. If that's what you're thinking about, I believe. All right. Oh, I'm 2 minutes late. All right, last but not least, I'm still, even though I gotta get on this meeting. Yo, y'all gotta keep your head up. I'm at the stage where I'm only like, if you want my help and you reaching out to me, we work together. But I'm not trying to drag any dead minds. I'm not trying to wake anybody up. We need to wake. No, I'm not waking no one up. They need to be already ready to be getting up or up, coming, hey, and talk. Listen, I already tell you, I can't save anybody. I'm not out here like the church trying to save souls. Really, I'm not doing it. Too much work. But if people come into my space, and I'm gonna help you. With all that going out there searching for souls, the church been doing that for years, and people still just as lost as they was thousands of years ago. And with that being said, I am out. Peace, prosperity, extreme wealth to everyone. Y'all have a great day. You have to go through something to accomplish something. Say it again. You have to go through something to accomplish something. Stop participating in your own problem. When you see the problem, how you resolve it is move away from it. When Peter wanted to walk on that water, he saw that storm, he started participating. Oh my God, this is a big storm. And it's bigger than me. He just saw Christ walking on water like it was nothing, like it was an everyday thing. And then he get out there, he start walking, yeah, I'm good. And he look over there and he start thinking the storm's bigger than him and bigger than Christ. And Christ just walked over it. See, he started to participate in his own failure. Christ had just walked on this water. He said, teacher, master, can I do it? Come on, come to me. He got out there, started walking, boom. Storm brew up. Oh, wow, that storm's bigger than me. He started to sink in his own consciousness. It started in his thoughts that he was going to sink, and he started to sink. But he had full, when he kept his eye on the Christ and he was walking towards him, he could do it. Because the Christ represents power. Christ represents success. Christ represents abundance. Christ represents peace, prosperity, and everything that's good. And when he kept his mind locked on that, he was able to do it. But as soon as he took his mind off it, his eyes off it, and looked over here at this what appeared to be a big storm to him, and he started to give praise to the storm in a way by saying, wow, and then he started to sing. See, anything you have fear of, you are making it your God. Because God didn't give you the spirit of fear. That's clearly said in the Bible.